Florida truck accident, 5 critical steps to secure your injury claim. You are cruising down I-95 when an 80,000-pound semi jackknifes across your lane and crumples your car in seconds. Before you reach the ER, the trucking company's investigator is photographing the scene, and your own phone's already ringing with unknown numbers. Miss these first critical steps and you'll watch key logbook data vanish, the 2-year deadline close in, and 6-figure compensation slip away. In the next few minutes, I'll show you exactly how to lock down black box evidence, prove federal hours of service violation, and hold every responsible party from driver to carrier to account. So you walk away with lifelong medical costs covered and your family's future secured, instead of letting an insurer decide what your recovery is worth. Looking at a truck accident case here in Florida, there are critical things you need to understand right from the moment the accident happens. I'm going to walk you through exactly what you're facing, what your rights are, and most importantly, what steps you need to take to protect yourself and your family. What makes truck accidents different in Florida? Let me start with something that might surprise you. When we're talking about truck accidents in Florida, we're not just dealing with a regular car accident that happens to involve a bigger vehicle. These cases are fundamentally different, and understanding that difference could mean tens of thousands of dollars in your settlement. First, the physics alone make these accidents catastrophic. A fully loaded commercial truck can weigh up to 80,000 pounds. Your passenger car weighs maybe 3,000 to 4,000 pounds. When that much mass hits you at highway speed, we're talking about forces that the human body simply wasn't designed to withstand. That's why I see traumatic brain injuries, spinal cord damage, amputations, and permanent disabilities in truck cases at rates I've never seen in a regular car accident case. But the legal complexity is what really sets these cases apart. With a regular car accident, you're typically dealing with one driver, one insurance company, maybe two. With a truck accident in Florida, I might be looking at the truck driver, the truck company, the maintenance company, the cargo loading company, the truck manufacturer, and sometimes even the company that leased the truck. Each of these parties has different liability policies, different legal responsibilities, and different strategies for avoiding liability. The federal regulations that could make or break your case. Here's something most people don't realize. Truck drivers and trucking companies in Florida have to follow federal regulations that regular drivers don't. These are called Federal Motor Carrier Safety Administration regulations, and they're incredibly detailed. They cover everything from how many hours a driver can be on the road, to how cargo must be secured, to how often trucks must be inspected. These regulations are actually your friend in a truck accident case. Why? Because they give us specific standards that we can point to and say, this is what the law required, and here's how the trucking company violated it. For example, federal law says a truck driver can only drive for 11 hours after being off duty for 10 consecutive hours. If I can prove the driver was on hour 13 when they hit you, that's a clear violation that directly contributed to your accident. The trucking companies know this, which is why they often try to destroy or hide evidence quickly after an accident. Electronic logging devices in trucks, maintenance records, driver logs. These documents can disappear if you don't act fast. I've seen cases where crucial evidence was, quote, accidentally destroyed just days after an accident because the trucking company claimed they didn't know a lawsuit was coming. Who's really responsible for your injuries? In Florida, we have something called vicarious liability, which means employers can be held responsible for their employees' actions. But with trucking companies, it gets more complicated. Some drivers are employees, some are independent contractors, and some trucking companies try to structure their relationships to avoid liability. I'll give you a real example. I had a case where a truck driver fell asleep at the wheel and caused a serious accident on I-95. The trucking company immediately claimed the driver was an independent contractor, not an employee, so they weren't responsible. But when we dug deeper, we found that the company controlled the driver's routes, required him to use their fuel cards, mandated when he could take breaks, and even told him what uniform to wear. Under Florida law, that level of control makes someone more of an employee, regardless of what the contract says. The trucking company also had a pattern of pushing drivers to meet unrealistic delivery deadlines, knowing it would force them to violate Hours of Service regulations. That showed deliberate indifference to safety, which opened up the possibility of punitive damages on top of regular compensation. The insurance game trucking companies play. Most passenger vehicles in Florida carry minimum insurance of $10,000 for property damage and personal injury protection. Commercial truck limits are required to pay much higher limits, typically $750,000 to $1 million or more, depending on what they're hauling. You might think that means you're more likely to get fair compensation, but actually it often means the insurance companies fight even harder. When there's $1 million policy at stake, insurance companies will spend serious money on investigators, accident reconstruction experts, and lawyers to avoid paying claims. They'll start investigating immediately, sometimes sending investigators to the accident scene before you've even been released from the hospital. I've seen insurance companies argue that a victim's pre-existing back condition, not the truck accident, caused their current injuries. They'll hire doctors to review medical records and testify that the impact wasn't severe enough to cause the reported injuries. They'll even use social media posts against you. That photo of you standing up at your daughter's graduation 3 months after the accident, they'll use it to argue you're not as injured as you claim. The evidence that could save your case. The key to winning a truck accident case in Florida is evidence, but not just any evidence. You need the right evidence, preserved the right way, obtained before it disappears. Electronic logging devices are gold mines of information. They show exactly how long the driver had been on duty, their speed at the time of impact, whether they hit the brakes, and sometimes even whether they were using their phone. But this data gets overwritten regularly, sometimes in as little as 6 months. Truck maintenance records can show whether the trucking company was cutting corners on safety inspections or ignoring known medical problems. I had a case where we discovered the trucking company knew about a brake problem for 2 months before the accident, but kept the truck on the road because taking it out of service would have been expensive. Driver qualification files can reveal a history of violations, failed drug tests, or medical conditions that should have disqualified someone from driving commercially. Sometimes we find drivers who have been involved in multiple accidents or who have suspended licenses in other states. The truck's black box or electronic control module records data about the vehicle's operation in the moments before a crash. This can show speed, brake application, engine RPM, and other critical information that contradicts what the driver might claim actually happened. You can see that preserving this evidence is critical, and having a lawyer to do that for you is imperative. What the 2-year deadline really means. Florida recently changed its statute of limitations for personal injury cases from 4 years to 2 years. This means you have exactly 2 years from the date of your truck accident to file a lawsuit, or you lose your right to compensation forever. But here's what most people don't understand about that deadline. It's not just about filing a lawsuit. The real work of building a strong case needs to start immediately. Trust me, the trucking company or its insurance company is starting to work on the case, sometimes within hours of the accident happening. If you don't, evidence may disappear, witnesses forget details, and your own medical treatment creates a record that insurance companies will scrutinize for any inconsistencies. I've seen people wait 18 months to call a lawyer, thinking they had plenty of time. By then, the company has already conducted its own investigation, surveillance videos have been deleted, and witnesses have disappeared. In some of those cases, we've still been able to handle the case and win, but it is much harder, and the settlement will be significantly lower. There are also some situations where the deadline is even shorter. If the truck was owned by a governmental entity, you might have to file a notice of claim within an even shorter time period. If there are federal violations involved, different deadlines might apply. The real cost of truck accident injuries. When I'm evaluating a truck accident case, I'm not just looking at your current medical bills. Truck accident cases often cause injuries that affect people for the rest of their lives. A traumatic brain injury might mean you can never return to your career. Spinal cord damage might require modifications to your home, ongoing physical therapy, and assistance with daily activities. I worked on a case involving a 35-year-old construction foreman who suffered a severe brain injury in a truck accident. His immediate medical bills were around $200,000, but when we calculated his lost earning capacity over his work life, it was over $1.5 million. The injury also affected his relationship with his family and his ability to enjoy activities he used to love. Florida law allows recovery for both economic damages like medical bills and lost wages, and non-economic damages like pain and suffering and loss of enjoyment of life. In severe cases, if we can prove the trucking company acted with deliberate indifference to safety, punitive damages might be available to punish the wrongdoing and deter similar conduct. Why the insurance company's first offer isn't your friend. After a serious truck accident, you'll probably get a call from the trucking company's insurance adjuster within days, maybe even hours. They'll sound sympathetic and helpful. They might even offer to pay some of your immediate expenses or offer a quick settlement to, quote, help you move on. This is not your friend. This is a trained professional whose job is to save their company money by getting you to accept the smallest possible settlement before you understand the full extent of your injuries and losses. I had a client who was offered $15,000 3 days after her accident. She had some broken ribs and pain in her side, but the adjuster assured her it was a fair settlement for her injuries. She wisely called our office first. After proper medical evaluation, we discovered she had internal injuries that required surgery and would cause permanent complications. Her case eventually settled for over $500,000. The insurance company knew that most people don't understand the full value of their claim and that medical complications often don't show up immediately after an accident. They were hoping to close the case before she realized how serious her injuries actually were. Taking action after your truck accident. If you've been in a truck accident in Florida, time is absolutely critical. Every day you wait is a day that evidence might disappear and witnesses' memories might fade. But you also need to be smart about the steps you take. Your first priority is always your medical treatment. Get checked out immediately, even if you feel okay. Adrenaline and shock can mask serious injuries for hours or even days after an accident. Follow up with any recommended specialists and keep all your appointments. Insurance companies love to argue that delayed treatment means your injuries weren't really caused by the accident. Don't give your recorded statement to the trucking company's insurance without talking to a lawyer first. They'll call sounding helpful, but they're looking for anything you might say that they can use against you later. Even innocent statements like, I'm feeling a little better today, can be twisted to suggest your injuries aren't that serious. Document everything. Take photos of your injuries as they heal. Keep all your medical records. Save receipts for any accident-related expenses. And write down everything about your daily life that is being impacted by these injuries. This documentation becomes crucial evidence later. The most important thing is to get an experienced truck accident attorney involved quickly. We can immediately send preservation letters to the trucking company requiring them to preserve evidence. We can start our own investigation while the scene is still fresh. And we can deal with the insurance companies so that you can focus on your own physical and emotional recovery. Your path forward. You now understand that truck accidents in Florida involve complex federal regulations, multiple potentially liable parties, and insurance companies that will fight hard to minimize what they pay you. You know that evidence disappears quickly and that the 2-year deadline is real and unforgiving. Most importantly, you understand that the decisions you make in the days and weeks after your accident can dramatically affect the outcome of your case. But here's something we haven't talked about yet, and it's just as important as everything we've covered today. What happens when your truck accident involves a boat trailer, a construction vehicle working near water, or an accident occurs on one of Florida's many bridges and waterways? These situations create additional legal complexities that can completely change your case strategy. In my next video, Florida boating accidents and your legal rights, I'm going to walk you through scenarios that combine truck accidents with maritime law, when federal admiralty jurisdiction might apply to your case, and why the location of your accident could determine which court system handles your claim. If your truck accident happened anywhere near Florida's waterways or involved any type of marine equipment or boat trailer, this information could be the difference between a successful claim and affecting your entire case in a negative way. I'll see you over there.